Welcome to our presentation today. At Surprenant Beneski, we provide strategic planning for your peace of mind. What does that mean for our clients? It means that we recognize that the subject of estate planning can feel overwhelming. Maybe it even makes you feel a little emotional. You have concerns, you have some goals, or maybe you need help identifying what your goals should be. You certainly have questions, and you would like to understand your options in plain English. That is what we do. We provide you with solutions that address your concerns, protect you, your loved ones, and your assets. This presentation should help you understand more about estate planning and the different aspects you may need to consider and the solutions we can provide.
Let's start with what is an estate plan. Estate planning involves planning for how an individual's assets will be preserved, managed, and distributed after death. It also takes into account the management of an individual's properties and financial obligations in the event that they become incapacitated. A lot of people have a rather simple view of estate planning. They want to tell their family who gets their stuff when they die. But estate planning is much more than just that. You want to think about your estate plans in two parts. What happens when you're alive, and then what happens when you die.
We'll look at being alive first. Whether you are young or old, rich or poor, unexpected things can happen in life. Along with the good times, and may you have many good times, there are going to be bumps in the road. A proper estate plan should make managing those bumps easier. In the case of a big bump, such as becoming ill or incapacitated, your estate plan should include documents that let someone you trust make legal, financial, and medical decisions on your behalf. Otherwise, these decisions will be made for you by the court. In addition to making sure your wishes are carried out in a timely manner, a proper estate plan could also save between $3,500 and $6,000 in court costs and legal fees.
Now for the death part. Everybody eventually dies, and you don't need a lawyer to tell you that. Your will is your set of instructions as to how you want to distribute your savings, property, and other assets upon your death. Typically, people leave their property to a relative, friend, or a charity. Your property may be distributed all at once, or in the case of a young heir, over time. There are a lot of factors to take into account when creating your estate plan, including your age, the ages of your beneficiaries, if there are any, salary, savings, assets, marital status, and children. But life doesn't stand still. Salaries may increase or decrease. Assets come and go. Children grow up and form families of their own, and the laws change.
Your estate is made up of everything you own. Your cars, home, your checking and savings accounts, insurance policies, investments, possessions, even that cool Beatles album collection you might have, furniture, you get the idea. Whether your estate adds up to $10,000 or $10 million, we've all got one thing in common. We can't take it with us when we die. Individuals have various reasons for planning an estate, such as preserving family wealth, providing for a surviving spouse and/or children, funding children or grandchildren's education, or leaving their legacy behind to a charitable cause. The most basic step in estate planning involves writing a will.
So to ensure your wishes are carried out, you need to provide instructions via a will. Who do you want to receive something of yours? What do you want them to receive? When do you want them to receive it? And let's make sure this happens with the least amount of taxes, legal fees, and court costs. A will-based plan includes your last will and testament and the 4 documents in an upcoming slide. Depending on your goals and assets, you may choose to complete additional estate planning that will be described in the following sections.
A will-based plan may be sufficient for you if you are relatively young and healthy, don't have a lot of assets, have a simple distribution plan, and don't necessarily mind that your heirs will spend some time and money in the probate court process.
The pros for a will-based plan is that it's least costly option, save approximately $3,000 to $5,000 plus the hassle and delay of guardianship and/or conservatorship. Peace of mind, avoid the court naming your decision makers, and it provides asset management without court involvement. Some of the cons include there are fewer distribution options, there are some administration costs once you die, probate course can last up to 2 years and add additional costs. Without a will, probate can cost on average between $4,000 and $8,000.
And as we mentioned earlier, our will-based plan includes 4 other critical foundational documents. First, the durable power of attorney. This lets you designate who you want to make legal and financial decisions on your behalf if you were to become sick or incapacitated and were unable to make them for yourself. The healthcare proxy appoints a healthcare agent who will make healthcare choices on your behalf if you are unable to make them for yourself. A HIPAA release authorization lets you name individuals to have access to your private and protected medical information so that they are not blocked by privacy laws. And lastly, the living will, also known as a personal directive, is a document that contains your wishes regarding healthcare instructions, including if you wish to receive life support. It provides guidance to your healthcare agent if called upon to make life or death decisions.
Let's look at taking the next step, trust planning. A trust provides both lifetime and after-death property management. Trust-based plans avoid the cost and delay of probate and can achieve many other goals, including keeping assets within the family.
You may want a trust-based plan if you have significant assets, such as a home. Perhaps you want to avoid the costs and delays and the public nature of probate court. Maybe you want to protect assets for your family in case of a child's divorce, death, or lawsuit. Maybe you don't like the idea that if your child passes, your assets could go to their spouse and/or the spouse's new significant other. Maybe you even have a more complicated distribution plan.
The pros in trust planning include it saves the cost and delay of probate, which averages between $4,000 and $8,000 depending on complexity. It keeps administration private. It allows you to keep assets in your family. Options to protect your child's inheritance in case they get divorced or are sued or need to file bankruptcy. If you become incapacitated, someone else can manage the trust while you're alive. There are more distribution options than a will-based plan. The cons include it costs more upfront than a will-based plan, and there still may be some administration costs.
Another solution-based planning that we offer is for clients who may have a member of the family with special needs. Special needs planning can help maintain a fulfilling lifestyle and secure the financial future for loved ones with a mental and/or physical disabilities. A well-drafted special needs trust allows the beneficiary to become and remain eligible for needs-based government benefits while also providing good money management. Our office is uniquely qualified to help families with special needs planning, as our managing partner, Dan Surprenant, is an active member of the Special Needs Alliance.
You might think that estate taxes are only something that the very wealthy need to worry about. The Massachusetts estate tax is levied on individuals with $1 million in assets, and it can take a large chunk out of an estate. Whatever your age or income, once you add up all of your assets, your home, your retirement accounts, and life insurance, it's quite possible that you've surpassed $1 million in assets, so it's time to plan.
You may want to consider an estate tax plan if you have a Massachusetts estate valued at more than $1 million. The value of your estate is determined by calculating the assets that are included in your estate, which may be your home, your life insurance policies, retirement plans, everything under your name, individually or combined.
The pros to estate tax planning is that it could save you between $30,000 and $100,000 in estate tax. It can achieve all of the other benefits outlined in trust-based planning. The cons include it is more costly to prepare, but the tax savings far outweigh the upfront costs. There still may be some administration costs as well.
Our experienced team can also help you think about other needs, including planning for minors, business succession planning, guardianship and/or conservatorship, and pet trust. Doesn't Fido deserve a plan?
None of us are getting any younger. So as your golden years approach, you want to plan to ensure you can maintain a good quality of life and the peace of mind that comes from knowing you've done all you can to protect your assets from the high cost of age-related medical care and long-term care, which averages about $12,000 a month. But in our office, we have encountered rates much higher. The ideal time to think about planning is while you are healthy, at least 5 years in advance of potentially needing long-term care.
Yes, 5 years is a key factor in planning as you age. When able, the best plan is to be ahead of that critical point in time and address long-term care planning well before you need it. Long-term care planning provides peace of mind by knowing that you have taken action to protect what you have worked so hard to accumulate from being depleted by the cost of long-term care. The time to consider this planning is while you're still healthy and don't anticipate the potential need for at least 5 years. However, if that just didn't happen, there are still solutions we may be able to offer. That's where our Mass Health Crisis Management Plan may help. If you didn't do advanced planning to protect your assets or become suddenly ill and a long-term nursing home stay is imminent, you may still be able to protect some of your assets while legally qualifying for Mass Health, also known as Medicaid. We can guide you through the complex rules and paperwork so that you and your loved one qualifies under Medicaid rules for any benefits you are entitled to while preserving as many of your assets as possible.
Creating an estate plan is a critical component to safeguard your family's future and leave a lasting legacy. We understand that starting the process isn't always easy. It's like making a resolution to get in better physical shape. We all know we should do it, but taking that first step can be daunting. There's no one-size-fits-all approach to estate planning. Our expert team is ready to discuss your specific needs and goals. Let us show you how easy it is to take that first step.
Let's meet the attorneys of Surprenant Beneski. First, Michelle Beneski is a managing partner, and she is a compassionate professional who provides peace of mind to her clients. She is a certified elder law attorney by the National Elder Law Foundation, which means she is uniquely qualified to serve the interests of older, maturing populations by having met comprehensive and strict requirements. Michelle is one of only 25 CELAs in the state of Massachusetts. Daniel Surprenant is Michelle's brother and partner in the business, dedicated to his clients and providing them with strategic planning that achieves their estate planning goals. Dan is also a certified elder law attorney by the National Elder Law Foundation. Attorney Surprenant has also served as president of the Massachusetts chapter of the National Academy of Elder Law Attorneys. Associate Attorney Brandon Wallaka is a passionate advocate for his clients, helping them create comprehensive estate plans designed to protect them, their families, and their assets. As an attorney at Surprenant Beneski, he enjoys helping seniors and clients of all ages protect their hard-earned assets and make important decisions regarding their estate and their loved ones. Attorney Erin Nunes is another associate at Surprenant Beneski. Over the years, Erin has proven herself as a committed advocate for the aging population and their families. She exhibits a passion for helping clients reduce stress and anxiety associated with the loved one becoming ill, for protecting assets from long-term care, tackling estate tax issues, and for protecting children's inheritances from creditors.
Our process is fairly simple, but does start with a little homework on your part. We have prepared a worksheet to help you document all of your assets, accounts, investments, etc. You will also need to write down your wishes, such as to whom you want to receive your possessions and to care for your family and pets. Your 90-minute consultation with one of our attorneys includes discussing your worksheet, personal situations, and goals. At that time, your attorney will provide you with their recommendations. The process usually takes between 4 to 6 weeks from your initial appointment to signing off on your final legal documents. We offer all our clients a complimentary 30-minute review every 3 years. This is important because there may be changes to the laws, to taxes, as well as your personal situation. Our commitment to deliver personalized goal-based plans and support. Dedicated experts committed to helping you navigate the complexities of the planning process and explaining the complexity of the law into layman's terms. And remember, we offer a complimentary 3-year review.
You can contact our client service team to book your consultation. Our helpful and friendly staff will walk you through any questions you may have. You can decide to meet with our legal team via a virtual meeting or an in-person meeting at one of our 3 office locations. The offices are in New Bedford, Hyannis, and Easton. In-person consultations are by appointment only at this point in time to help maintain your comfort and safety. You can reach our client service team via the Contact Us page on our website, which is www.myfamilyestatePlanning.com, or by calling our main number at 508-994-5400.
So call us today to give your family peace of mind for generations to come.